So when you've successfully suppressed evidence and you found evidence that shouldn't be available in the trial, how significantly does that suppressed evidence, if proven, impact the outcome of a trial?
It's oftentimes what we call case dispositive, or it's a total game changer. Oftentimes cases won't go forward. So let's say you have a he said, she said sexual assault case. There's no forensic evidence. There's no DNA. There's no eyewitnesses. You just have an alleged victim says, well, me and Corporal Jones were at a bar and I was really drunk and we went back to the barracks. We had sex and I was too drunk to consent. And I reported him 3 weeks later when my husband found out about it, right? Kind of common. Corporal Jones comes in, he talks to NCIS, he gives this admission after 6 hours, then it gets suppressed. Well, there's no case anymore. What are you going to call just her to testify I was really drunk? Okay, great, bring it, right? Bring that to trial. We'll have another 20-minute acquittal. And so oftentimes it can be case dispositive where the case, it's a total game changer and the cases oftentimes don't go to trial. Now, if there's other evidence, let's say there's forensic evidence, there's eyewitness evidence, that may not be the only piece of evidence, a case can still go forward. But the strongest proof of guilt, oftentimes, that we know in American jurisprudence is someone's confession. Because if you confess to something, whether it's a true confession or not, and anyone who doesn't believe false confessions happen, they're just not living in the reality. We know false confessions happen. Look at the Innocence Project. Look at all of the DNA exonerations which happen where people have been incarcerated 5, 10, 15, 20 years based on these confessions. I put that again in quotes, where DNA later exonerates them. And so it's a real problem. So oftentimes the cases won't even proceed. They won't go to trial, but sometimes they will. And then you've got to just be very careful that you don't inadvertently open the door and have that statement come right back in by doing something stupid as a defense attorney. If you're a military service member and you've already made a statement or you've given an admission or a confession that isn't true, or you've had a cell phone seized, or there's evidence that looks damning on its face that you think is going to be used against you at trial, let me tell you what, all hope is not lost. You still can fight this. You can still take this case to trial and it can still be won. Give me a call at 813-669-3500 or do additional research at my website, BileckiLawGroup.com, and get us into the fight.